In real estate practice, one of the most frequently misunderstood areas of disclosure involves what is not required to be disclosed. While Arizona law mandates that a licensee and seller must disclose all known material facts that affect the value or desirability of a property, the law also clearly defines certain items as non-material, meaning they do not require disclosure. These are often referred to as stigmatized property conditions, and they are governed by ARS Section 32-2156, which establishes that some events or characteristics, though sensitive or emotional in nature, do not constitute material defects and therefore are not legally required to be revealed to potential buyers. Understanding the distinction between material and non-material facts is critical for real estate professionals, as it ensures compliance with the law while protecting the privacy and rights of property owners. The stigmatized property law was created to balance transparency with fairness. In the 1980s and early 1990s, several high-profile lawsuits across the United States involved buyers who attempted to rescind contracts after discovering that a property had a tragic history, such as a prior homicide, suicide, or even alleged paranormal activity. In Arizona, the legislature recognized that these factors, while possibly distressing to some, do not necessarily affect the property's physical condition or market value. Thus, ARS Section 32-2156 explicitly states that a licensee or seller is not liable for failing to disclose that a property is or has been the site of a natural death, suicide, homicide, or any other felony. For example, if a home was the site of a homicide several years earlier, the seller and licensee are not obligated under Arizona law to disclose this fact unless directly asked by the buyer. Similarly, a property that was previously occupied by someone with a disease that is not transmitted through occupancy, or the property, such as HIV or AIDS, is not considered materially affected. This provision was added to protect privacy rights and prevent discrimination. The Arizona legislature, in drafting this section, intended to avoid stigmatizing certain groups or properties without scientific justification. However, it is crucial to remember that while stigmatized factors are excluded from disclosure requirements, material facts still must be disclosed if they affect the property's use, structure, or value. For instance, a violent crime that resulted in significant property damage or a police investigation that revealed environmental hazards would create a material condition that must be disclosed. The key distinction is whether the event left a physical or financial impact on the property. The law also applies to certain types of neighborhood conditions or circumstances that may influence a buyer's decision, but are not considered material by definition. A licensee is not required to disclose the presence of registered sex offenders in the area. However, a buyer can access this information independently through law enforcement or the Arizona Department of Public Safety's online registry. Real estate professionals should direct buyers to official sources rather than providing personal opinions or neighborhood gossip, which could lead to claims of steering or discrimination in violation of the Fair Housing Act and the Arizona Civil Rights Act. Another common area of confusion involves so-called haunted or paranormal properties. While movies and folklore often sensationalize such listings, Arizona law does not consider alleged supernatural activity to be a material fact. A licensee's duty to disclose extends only to factual conditions affecting property value or habitability, not to subjective perceptions or rumors. However, if a buyer specifically asks whether the property has a history of haunting, the licensee should respond honestly to the best of their knowledge, while clarifying that such matters are not recognized by law as material defects. Licenses must also exercise caution when discussing sensitive issues with buyers and sellers. While it may be tempting to over-disclose to avoid liability, revealing non-material information could inadvertently breach confidentiality, violate privacy rights, or create unnecessary stigma. For example, disclosing that a previous owner had HIV or AIDS would violate federal fair housing protections for individuals with disabilities. Therefore, the safest course of action is to focus disclosure strictly on facts that relate to the property's condition, structure, title, or financial encumbrances. To illustrate, consider a scenario where an agent lists a home that was previously the site of a suicide. The property has no structural damage or environmental hazards, and the event occurred several years ago. The agent receives an offer, and the buyer later discovers the event through online news archives. Expressing shock that it was not disclosed, the buyer cannot legally void the contract or claim misrepresentation because the event is not considered a material fact under ARS Section 32-2156A. Conversely, if the suicide caused property damage, such as significant blood contamination requiring remediation, that physical impact would become a material condition requiring disclosure. Another example involves a buyer who inquires whether the surrounding area has a high crime rate. The licensee is not required to provide personal opinions or crime statistics, as this could be construed as steering under fair housing laws. Instead, the licensee should direct the buyer to local police departments or official crime mapping tools to independently evaluate neighborhood safety. This practice maintains neutrality, avoids potential bias, and complies with Commissioner's Rule R4-28-1101, which prohibits discrimination or steering in real estate transactions by dealing fairly to all. ARS Section 41-1463. Review Summary. The Arizona Stigmatized Property Law under ARS Section 32-2156 clarifies that certain events and characteristics do not require disclosure because they do not materially affect property value. These include natural deaths, suicides, homicides, felonies committed on the property, prior occupancy by individuals with diseases not transmitted through occupancy, or alleged paranormal activity. Licensees must focus on disclosing material defects that impact a property's physical or financial condition while protecting privacy rights and adhering to fair housing principles. When in doubt, they should disclose only facts relevant to the transaction and direct clients to official public sources for sensitive or personal information discussion. Why doesn't Arizona law require disclosure of a death or crime that occurred on a property? Answer: because such events do not materially affect the property's condition or market value under ARS Section 32-2156A, and requiring disclosure could unfairly stigmatize properties or violate privacy rights. If a buyer asks about neighborhood safety or local crime rates, what should a licensee do? Answer: the licensee should avoid giving opinions or unofficial data and instead direct the buyer to local law enforcement or verified public resources to ensure compliance with fair housing laws. What must a licensee disclose if a stigmatized event resulted in property damage or contamination? Answer: the licensee must disclose the physical condition or hazard itself, as it constitutes a material defect affecting the property's value. Closing remarks. Arizona's stigmatized property law reflects a balance between transparency and fairness. While the duty to disclose material facts remains absolute, licensees must understand the boundaries of that duty to avoid overstepping privacy protections or engaging in discriminatory behavior. The guiding principle is that disclosure is required for facts that affect the property, not the people who live there or events unrelated to its condition. Maintaining professionalism, sensitivity, and adherence to ARS Section 322156 protects both the client and the integrity of the real estate profession.